If you've been keeping up with the news recently, you've probably come across the Apple v. Epic case. Although Epic filed their original lawsuit in the US back in 2020, the issues raised by the case are more relevant now than ever. Over the last 6 months, we've seen unprecedented changes in the industry, from the EU's Digital Markets Act to a landmark federal antitrust case against Apple in the US. I'm Karen McCabe-Stash, and today we're diving deeper into the Apple v. Epic case, its relationship to other developments in tech antitrust regulations, and what all this could mean for the future of in-app payments and Apple. Let's head back to 2020 when this all started with something called Project Liberty. In August of that year, Epic Games intentionally violated App Store and Google Play's policies. How? By offering Fortnite users an alternative direct payment processing option in-app that bypassed both platforms' native payment solutions. Nicknamed Project Liberty, Epic's updates were the first move in a premeditated strategy meant to provoke the big platforms. And it worked. Apple and Google quickly responded by removing Fortnite from their app stores. Then the legal proceedings began. We'll get into Google's legal battle against Epic at a later time, but for now, let's focus on Apple. Epic's main argument was that Apple's policies were illegal, monopolistic, and anti-competitive. So they filed a lawsuit challenging his policies. And Apple? They countersued Epic, accusing them of breaching their developer agreement and seeking damages for lost App Store revenue. In September 2021, a federal judge issued a ruling in the case. Apple mostly came out on top, winning on 9 out of 10 counts. But there was one count that Epic won, and that had to do with Apple's anti-steering policy. This App Store rule prevents developers from linking to or telling users about alternative purchase options from inside their apps. And the judge found that this policy violated California competition law. As you can imagine, Apple and Epic weren't entirely happy with this ruling, so both appealed. In 2023, the appeals court ruled that Apple's anti-steering policies were a violation of California law and dismissed Epic's antitrust claims. This is pretty much just a confirmation of the original decision. The legal battle didn't end there, though. Both Apple and Epic appealed to the Supreme Court. Finally, the case was resolved in January of 2024, but not with a ruling. The Supreme Court declined to hear the Apple v. Epic case, leaving the original decision in place. So what's happened since? Well, Apple was forced to comply with the anti-steering part of the ruling, and this meant updating their App Store review terms so developers could communicate with players about alternative purchase options. As part of their updated terms, Apple introduced a link-out policy in the US. Developers can include links to alternative payment options, like links to web shops, in their apps. But there's a catch. Developers still need Apple's permission to include this link. And get this, if a purchase happens through that link within 7 days of the click, Apple takes a 27% cut, not much less than the original 30%. This 27% fee didn't sit well with Epic, who decided to go to court again. In a March 2024 filing, they claimed that Apple's updates were insufficient and blatantly violated the court's orders. And they weren't alone. Several other tech giants joined their claim, including Meta, X, Microsoft, and Match Group. Things are already moving quickly. In April 2024, the judge made an initial ruling in favor of Epic. Now a hearing can be held in May to evaluate whether Apple's new policies actually complied with the court order. Here's the thing. The Apple v. Epic case isn't the only battle taking place between the two companies. And actually, it's only a small part of a much bigger campaign against Apple's practices. Even though Apple seemed to come out on top in the original Apple v. Epic decision in 2021, recent events show that Apple's troubles won't be over anytime soon. Let's head over to Europe to explain more. The groundbreaking Digital Markets Act came into effect in March 2024, and it's already forcing real changes in the Apple ecosystem. Under the DMA, Apple has been forced to allow downloading of apps outside of its App Store for the first time. And Epic was ready to capitalize on the new policies by launching their own competing App Store. This is where things get tricky. Apple had gone ahead and reinstated Epic's account in February 2024 after deleting it in 2020, after the launch of Project Liberty. But on March 6th, the day before the DMA was rolled out, Apple suddenly banned Epic's account again, blaming their critique of Apple and past violation of the App Store policies. Within days, Apple had to backtrack on this decision after the EU announced it would investigate the move. Between the official Epic v. Apple court rulings in the United States and the actions happening out of court and across the globe, like with the DMA sanctions, there's new light being shed on alternative payment options. And more than that, this awareness is turning into real opportunities, protecting developers' rights to communicate directly with users and even opening up sideloading in the EU. Don't be surprised if this trend turns into the standard, and you'll soon be able to offer your app on other stores and use third-party payment gateways like web shops. Get ahead of the trend and start building a direct relationship with your users today. At Stash, we can build you a web shop that encourages higher retention, engagement, and LTV. Reach out to us to learn more.